Hello, everybody. This is Erica Johnson, Ambler and Keenan. Thank you for joining us tonight. We're going to talk today about what the Supreme Court ruling means to you and your estate plan if you have one, or if you don't, we'll kind of talk through that as well. A little bit about me, just so you know. I have a broadcasting management degree from Northern Arizona University, but then I did go to law school, so we're going to talk about that today. I belong to all sorts of organizations, most of which revolve around the GLBT community and estate planning, because that's basically what I do. I also practice in the areas of probate and trust administration. So if a loved one passes away in Colorado and we need to help family through that process, we can do that as well, just so you're aware of that. So again, I appreciate you joining us tonight. I am a lawyer, so I'm going to start with my legal warning that, one, I'm only licensed to practice in Colorado. I'll touch on some federal things, obviously, today because this is a federal court case that was issued, but I can't give legal advice about another state, so everything I talk about specifically tonight that has to do with a state will be Colorado. And the other is that this is not legal advice, so please don't run out and say, well, my lawyer said this or my lawyer said that. I can't really give you legal advice over the phone when I can't see you and don't know what the question is, or even if I answer a question, it's going to be just information. So we're going to roll from there. I'm going to start with just a little bit of history. I won't give you a ton. Most of this stuff you're probably fairly aware of. But I do want to say some of this stuff because these things still exist. So for instance, July 1st of 2009, Colorado passed a law that said we have what's called a designated beneficiary agreement. So where I have couples, same-sex or opposite sex, that are not married and not in a civil union. If they're not married and not in a civil union, this is a contract that these two people can sign that will give each other 16 of the rights that people who are married or in a civil union automatically get. Now, there are a ton of rights, 16 of them. I'm not going to go through them. I would invite you that if you want to know more about the designated beneficiary agreement, one, if you're my client, you probably already have one. If you're not, it's something we do as a part of your estate plan. Two, you can get online and look at the document. The Designated Beneficiary Agreement, or Colorado Designated Beneficiary Agreement, if you Google that, you'll find the form. And the way I want to describe it is if you have a full estate plan, wills or trusts and powers of attorney, you've taken care of 14 of those rights. And there are 2 that you have not taken care of unless you are signing this designated beneficiary agreement. 1, the right to sue for wrongful death. If somebody kills your partner, you would then have what we call legal standing to sue that person for wrongful death. The other is to seek workers' comp benefits. If the person you signed this contract with is killed at work, you could seek workers' comp benefits the same way a spouse could. So again, if I have clients that are not married or in a civil union, this is a document that we will often use to make sure that they have those 2 rights vis-a-vis each other. Okay? So that's the designated beneficiary agreement. If you are married or in a civil union and you had one of these, it's basically voided by being married or in a civil union, and you get those 16 rights plus others that we're about to talk about. So that's how that one works. Next, a few years later, after we had the designated beneficiary agreement, along came civil unions. May 1st of 2013, Colorado got civil unions. States recognition as spouses. Basically what the law said is if you're in a civil union, you get the benefits, protections, and responsibilities, all rights the same as spouses, except you must file your taxes as 2 separate individuals. Okay? So civil union partners still exist. Civil unions, I have been told there is nothing on the horizon to get rid of civil unions. At least Senator Stedman, who was instrumental in passing the civil union law, has said that there's no plan to get rid of them. He still thinks there's a place for these, and there probably is. So one option for people is to still get in a civil union rather than be married. Before we had same-sex marriage, an out-of-state same-sex marriage was automatically a civil union in Colorado. Now that we have same-sex marriage, an out-of-state same-sex marriage is a marriage here. Okay, so if you want to get into a civil union in Colorado, you apply for a civil union license in one of the counties in Colorado, and once that is issued, it's very similar to applying for a marriage license. You will have Colorado recognition of your relationship. You will not have federal recognition of your relationship. Okay, so I'm not going to get into a great amount of detail here tonight about civil unions. On our website is another webinar from May of 2014, and it is really about civil unions and what they offer and what they don't. Now, keep in mind that was before we had same-sex marriage, so there may be a couple of statements on there that aren't applicable, but for the most part, it will set out what are some of the rights you get if you're in a civil union and rights you don't get if you're in a civil union. So that you might find helpful. Again, you can find it on our website near where our webinars are located. Okay, so civil unions was May 1st of 2013. Then, as most of you know, June 26th, 2013, we had U.S. v. Windsor, and the federal government at that point, what that said was that the federal government must recognize same-sex marriages that have been approved by the states. So at that time, we started to see more and more states pass same-sex marriage laws. And I thought it was kind of interesting because it did grow really quickly. By April of 2014, we had 17 states in the District of Columbia that had same-sex marriage. So those people that lived in those states were married under state law and federal law. Okay? In May of 2015, it was up to 37 states and some counties in Missouri that had same-sex marriage. Okay? So it grew rather quickly, as again, most of you are probably aware. But again, that Windsor case just said the federal government must recognize same-sex marriages, not that all states had to perform them. That's where we've gotten to, or honor other states' marriages. That's where we've gotten to now. So about then was when things started to kind of explode. And so in 2014, for Colorado, this was instrumental in Colorado, 2014, the U.S. Supreme Court declined to hear the first same-sex marriage appeals that came up. And they said, nope, we're not going to hear them. What that meant was that at that point, the 10th Circuit ruling that said you can't ban same-sex marriage became the law in Colorado. So as of October 7th of 2014, the Colorado Attorney General said all 64 county clerks in Colorado will now begin issuing marriage licenses to same-sex couples. So if you were married out of state before October 7th of 2014 in a state where it was legal, your marriage became legal in Colorado as a marriage on October 7th of 2014. Right before October 7th, like on October 6th, your out-of-state marriage, same-sex marriage, was a civil union in Colorado. As I always say, it's clear as mud, right? But as of October 7th, you are fully married under Colorado law, and we're able to marry in Colorado as well, okay? So a couple that was legally married in a state or country where it was legal is now automatically married in the eyes of Colorado and the federal government. You don't need to go do anything. You are automatically married, and that was kind of a hurdle that was hard to think about because it was like, well, we're used to being denied, denied, denied. Don't we need to do something? Don't we need to have something to prove to people? The answer is no. You can start to think of your relationship as heterosexual couples do, and that is, if I get married in Colorado, I am magically married in every other state. That's it. I'm done. I'm married in every other state. So all the rights and obligations of marriage now apply to your marriage, okay? So there is one period I want to talk about, and that was in the middle of 2014. Denver, Boulder, and Pueblo clerks, you'll probably remember seeing this one on the news, performed roughly, I think I've heard, 350 marriages. So they issued 350 marriage licenses. The legal question was, did the clerks, and this was between the Supreme Court Windsor ruling and October 7th, when the Attorney General said, go, okay? Between the Supreme Court Windsor ruling and October 7th of 2014, 350 licenses were issued. The question is, did the clerks have the legal power to issue those licenses? The issue here is that the 10th Circuit had what's called a stay in place. A stay is kind of like a pause. They said, okay, yeah, we're going to issue this, but it stayed on this next action, okay? It's not valid until this next action. This question, did the clerks have the legal power to issue these licenses, was never answered. Still remains unanswered. That concerns me. I don't know. Again, I tell my clients, I have no idea. This is uncharted territory. Nobody knows if that will ever be an issue. It might not be. I will tell you that I've spoken with Deborah Johnson, the Denver Clerk and Recorder, and she has indicated that they will issue another license free of charge to anybody who was married during that gap. I guess the only issue with that is which date of recognition then applies. And that's kind of the risk, I guess. So some of my clients have said, we're just going to stick with our marriage license that we got during that gap. Some have said, we're going to go down and get a new license. Boulder won't reissue, I've been told, licenses or issue a new one or do anything. They say, nope, it's totally valid and you don't need a new one. I'm really not sure whose opinion is right, but that's kind of a thing that you have to weigh the pros and cons and decide if you want to get a new one or not if you were married during that period. Okay, so this is an issue, and it's going to sound kind of silly. People chuckle when I say this. If a person married another person in a same-sex marriage that was never dissolved, they, after October 7th of 2014, were automatically back in a marriage for Colorado with that person, or in a marriage with that person. What happened was a lot of people had gone over the past 10 years. Let's say they went to Massachusetts in 2003 and they got married. They came back and lived in Colorado, and they split up in 2008. They never went and got a divorce because they're like, well, we're not even married under Colorado law, so whatever, see you later. Packed up their cars, headed the opposite directions, and never dissolved that marriage for Massachusetts. The problem is, as of October 7th of 2014, that marriage was valid here in Colorado. And before they can marry someone else or into a civil union with someone else, they need to legally dissolve that marriage. Otherwise, they would be married to two people, which is, as we know, not legal. Okay? So that is a concern, and if you are in a legal marriage with somebody in that situation, you need to talk to somebody, or at least talk to them, and get it dissolved legally. Okay? All right. This is a biggie that gets really confusing for people, and I don't know that I can take all of the confusion out of this situation, but let's try a little bit. Common law marriage. Colorado recognizes common law marriage, okay? You will hear, if you ask 10 people on the street, how do you become common law married? You will hear probably 10 different answers. Some will say, oh, we have to live together. Some will say, oh, we have to be together for 7 years. Oh, we have to own a bank account together. Whatever the answer is. None of those are really right. So there is no standard test to determine if two people are in a common law marriage. And let me say that now that we have legal marriage in Colorado, a same-sex couple could find themselves common law married in the exact same manner as an opposite-sex couple. Okay? So what the test is have they held themselves out as married, and have they intended to be married? Have these two people held themselves out to the world as being married? Now, what does that take? I don't know exactly. I can't tell you. It's a judge who's deciding this. I can tell you that just living together does not make you common law married. Just owning things together does not make you common law married. The question is, did you tell people you were married? Did you, well, certainly if you, well, let's say you got each other on health insurance as spouses. Well, you probably just married yourselves because you told that company that you were married, and that is holding yourselves out as married. And if you really didn't think you were, then I guess you were committing fraud on the company, and that's probably not an argument you want to have to make. So holding yourselves out would be telling people you're married, Filing taxes is married. Getting on each other's insurance is married. There's no set test. Okay, so what I tell people is if you don't want to be married, don't tell people you're married. Don't introduce each other as your spouse. Don't do those kind of things, okay? If you do want to be married, go get a marriage license. Don't get caught up in this gray area. Common law marriage can get very messy. And so what I tell people is don't put yourself into that muck. Either don't say you're married or get married, okay? If you have other questions, I can get you to an attorney, like a family law attorney, who can say, yeah, I think this is an issue, or I don't think you have a problem, okay? So just be cautious of common law marriage. You could create a marriage when you did not intend to. Next is whether there are common law civil unions. Could you hold yourselves out as being in a civil union and then therefore be in one even without having to go down and get a civil union license? I know there are attorneys who are arguing that in court right now, and I think there's been a judge or two that has found these two people were in a common law civil union. It kind of grows out of court cases. And one of the main places we'll see it is, you'll see later when I talk about this, when someone dies, if they were in a civil union or a marriage, their spouse or partner has a right to part of their estate. And what will happen is John will die, and his partner Bob will go into court and argue, I was in a civil union with John, and I get part of his estate by being so. And he will argue to the judge and show the judge as much as he can that they held themselves out as being in such a relationship. Again, will it work? I don't know. Up to the judge. So common law marriage, common law civil union, if you don't want to be married, don't hold yourselves out as so. And if you don't want to be in a civil union, don't tell people you are. Okay? And that's that one. So I'm going to talk a little bit about children. Even if you don't have children, I think it's important that we all kind of know what's going on in our community around this issue. First of all, in 2007, we have second parent adoption that came along in Colorado, and these still exist. So if you are not in a civil union or married, if there's no civil union or marriage, you can still adopt your partner's child. Okay? Any person over 21 does not need to be married or in a civil union with that sole legal parent can seek a second parent adoption. Now, the sole legal parent has to agree. So you can't try to go adopt someone's kid that doesn't agree. The sole legal parent must agree. And in order to accomplish this, you have to get a home study and parenting training. And then if you have passed all that and you go to a hearing, the judge can issue, yep, you're a second legal parent, and they will put your name on that kid's birth certificate, and it'll show mother and mother or father and father. Okay? So second parent adoption still exists in Colorado. And that's for people who are not married or in a civil union. If you are in a civil union or married, okay, you can do what's called a step parent adoption to adopt your spouse's or partner in a civil union's child. The difference between step parent adoption and second parent adoption, one, you have to be legally related to the other parent, and two, no home study. No home study, no parenting training, no background checks. You do have to do an FBI and CBI background check, but no full home study. There's still a hearing required, and a judge has to order it. Okay, but it is a little smoother process without having to do all the home study and all that. Out-of-state birth certificates. When you have a child who was born in another state, we've often have issues where we send the adoption paperwork to that state to amend the birth certificate, and they kind of freak out. They're like, what? I don't know. We can't put two moms on here. So they legally have to, and eventually I think all those battles have been won, but it can be an issue. So there is a Colorado statute that says if the state where the kid was born refuses to issue a new birth certificate, Colorado will issue that child a birth certificate, which seems weird because the kid wasn't born here. But there is a statute that will get that accomplished. So that's step parent adoption. All right, civil unions and children. If you are in a civil union at the time the child is conceived, what the law says, and this is at conception in a civil union because it's a little different for marriage, the responsibilities and rights of the biological partner to the child are treated as if they're spouses. And what that means is if you're in a civil union at the time the child is conceived, we're going to presume that the non-bio partner is the parent. It's called a legal presumption. It's also called called a rebuttable presumption, meaning someone could argue you were not the legal parent. So that's why it says, should you get a court order anyway? That's up to people's individual taste, and if anybody is in this situation, I would urge them that we could talk about that more at length so I can give more specifics as to options. And you can get a court order that basically backs up this presumption, so you have a judge's order, not just a potential presumption of parenthood. Okay? Again, I'm glad to talk to folks about that if they have that issue. Marriage. The way marriage works is if a child is born during the marriage, both spouses are presumed to be the parents. Okay? It is still, again, what we call a rebuttable presumption, meaning somebody could come in and argue. So if you think about it, when a wife gives birth and her husband she's married to a man, we just presume he's the father. They don't blood test the guy. We presume he's the father, and she puts him on the birth certificate. And if John down the street comes running in and says, whoa, that's not his kid, that's my kid, he can rebut that presumption. He can prove that wrong, and then he'll prove that he's the parent. Okay? Again, should people get a court order anyway? Can they? Yes, they can. We can get a court order from a judge that says this presumption is backed up. These are the two legal parents. The reason some people are doing that is because the law says a husband is presumed to be the father if his wife gives birth. And that's a problem, because in a same-sex relation, or potential problem, in a same-sex relationship, you don't have a husband or you don't have a wife, okay? So to use those two terms could be problematic. I have no idea if that's ever going to be an issue, okay? I don't know, and I wouldn't count on the law ever being clarified, but hopefully it will at some point, to say if a spouse gives birth, the other spouse is presumed to be the parent. But that's not the way it's written right now. So some of my clients are getting a court order that says, the judge says we are both legal parents, and we're not just relying on this presumption. So again, glad to talk to folks if they have that issue come up. You can let me know, and we can set up a phone conference or something. So that's our issue there. Next thing is, we're married, we're done, right? I hear on a weekly basis, and have since even civil unions came along, but certainly since marriage came along, well, I don't need you, or not, I don't need your estate plan, I don't need a will, I don't need a power of attorney now because I'm married. I mean, we have been, as a community, kind of pounded into us that the reason we had to do all this planning was because we were being discriminated against and we weren't able to get married. That's not really true. The reason we had to do all this planning are the same reasons that married couples do all this planning, and that is because the law doesn't necessarily default straight to your spouse for a lot of things. And it may default to your spouse, but it may lead to a more complex process for your spouse to have to go through. So I do estate planning all day, every day, and I will tell you that I have been doing this for married couples, heterosexual married couples, for the past 15 years, and it's necessary for everybody. And I just kind of want to go through here and just talk about why, because I know it sounds self-serving for an estate planning attorney to say, hey, you need this, okay? But here's a few reasons why. Medical decisions. Doesn't Colorado law provide that my spouse or partner in a civil union can make all my medical decisions if I can't? The fact is, it does not say that, okay? Colorado has what's called a Medical Proxy Decision Maker Act. If you can't make your own medical decisions, all interested parties, and that's what the law uses, are supposed to get together and pick that decision maker who will make your medical decisions. That's your proxy, okay? If you are married or in a civil union, good news at least, that puts your spouse or partner as one of the interested parties that gets to chime in and pick a decision maker, but it does not make them the decision maker, okay? It says they're at the table picking one. So that has caused lots of problems for many of my clients, where their partner stands or their spouse stands, and there are their parents and their adult kids or their siblings or their adult nieces and nephews, and their partner or spouse is just one voice trying to say, I'll make the decisions. And if people disagree, it gets very messy. So really what we do is we do what's called a healthcare or medical power of attorney that says, we're not dealing with this proxy stuff. Forget it. I want my spouse or my partner in the civil union to be the one that makes my medical decisions. You all can be here and talk to them, but they are the decision maker. And it should also name some backup agents, okay? And still, it needs to make sure that it says whoever I've appointed can visit me in any hospital or healthcare facility. Now, marriage will help in this one area, and that is if you go to a hospital, there are certain parts of the hospital that will only allow quote-unquote family members in, right? ICU, sometimes emergency rooms. So being married should help with that issue, okay? But civil union, it's supposed to allow them in, but people don't even know what civil unions are, much less that they still exist and will continue to exist. So again, in every medical power of attorney that we write, and I think most good ones would say, this lets this person visit me, okay? HIPAA, oh gosh, I'm sure you've heard of HIPAA, and those of you that work in the medical world, you know, just love HIPAA. So the issue with HIPAA is it's a Medical Privacy Act, a federal law that says healthcare providers are not to share your medical information with anyone, and that includes spouses. Now, I will say that HIPAA laws are often broken by, I don't know, culturally. When a spouse asks for information, generally the healthcare providers will give it. Not always, because I've had clients have an issue with this. So anyway, the bottom line is not just your spouse may need this information, but the people you appointed in your powers of attorney might need this information. So you should have a HIPAA release that releases your medical records to your backup power of attorney and your primary powers of attorney. And having one just at Kaiser or having one just at your doctor's is not what I'm talking about. You need one that covers any healthcare provider, because if you're a Kaiser patient or you have a particular doctor and you get hurt, they may haul you to Swedish Hospital, at which point the HIPAA release you had over at Kaiser or at your doctor's is no good. So again, it's a general release, all right? So a medical power and a HIPAA release, pretty important. A living will, I'm not going to get into the details, but this is really a same deal for single, married, civil union folks, okay? Being married does not alleviate the need for a living will. And the perfect case to show you that is really that the most famous case about living wills in probably the history of the country is about a woman who was married, Terry Schiavo. She was married. That did not solve her problem, right? She was in a persistent vegetative state. Her spouse and her parents got into a legal battle. She had no living will, and that legal battle went on for years about how long she needed to stay on that respirator and feeding tube in her case. So instead, a married person, a single person, a civil union partner, we do a living will that sets out your wishes for how long you want to stay on life support if you're terminal, how long you want to stay on life support if you're persistently vegetative. That was added in the year 2010. And how long you want to stay on a feeding tube if you're on one in those cases. So again, being married or in a civil union, that doesn't really solve the problem of the living will issue. So that's something that I think is really important for everybody to have. Oh, these are pleasantries. It's a beautiful evening, and here you are. Now we get to talk about the last one here, and that is disposition of last remains. It's legally binding on the funeral home. Do I want to be cremated? Do I want to be buried? What do I want to happen? What kind of ceremony do I want? There is a priority that is created. If you have not said in writing, I want to be buried or cremated, then there is a statutory priority about who gets to make those decisions. The first person on the list is your personal representative in your will, which is your executor, okay? Second is your partner or spouse, partner in a civil union or spouse, excuse me. So again, no matter what, need a last remains declaration to say, I want to be buried or I want to be cremated, and this is who I want to be in charge. So that's a good thing to have. Oops, sorry. And then this is the biggie that I often find, and I hear it all the time. Well, if I'm hurt, my spouse can handle my finances, or we own everything jointly. So if I'm hurt, that's not a problem. Well, you can't own everything jointly, so we'll get to that. But your spouse does not automatically have the power to sign on your behalf just because you got married, okay? Marriage does not give you the right to sign that other person's name, okay? No one can access, let's say you have an individual bank account and you get hurt. They can't get into it. Let's say you have an IRA. Again, that's not a joint account. It cannot be a joint account, and the fact that your spouse might be the beneficiary of it does not give them access to it while you're alive. So if my spouse is hurt and I need to access her IRA or her 401k to get money out to take care of her, I am going to be at a loss to do that without a power of attorney. And if I don't have a power of attorney for her, I'm going to have to go to a court and get appointed as what's called her conservator, and it's a big pain. And that whole process is generally going to cost me more than an estate plan would. So they can't access your retirement plan. They can't access your bank account. And in fact, if you need to sell the house, let's say your partner is incapacitated and you need to downsize, or you need to sell the house to take care of them, to get money to take care of them, you can't. You cannot sell, quote, your partner's half of the house. You can't sign a contract for them unless you have a power of attorney, okay? So what we do is we call it a durable general power of attorney, and again, it makes financial decisions, appoints who you choose. You can name your spouse first. You don't have to. Some people don't want their spouse to be first to deal with their finances. That's okay. But you can name your spouse first. You can name backups, and that's the kind of stuff that we cover in the durable general power of attorney, all right? And finally, I'm not going to get into the details, but you need a will or a trust, one or the other. And that sets out who inherits your property, how do they inherit it. The fourth bullet, did you accidentally disinherit your side of the family? People who say, well, I'm married, so if I die without a will or a trust, my spouse is going to inherit everything. It's called intestacy. You die intestate without a will or a trust. So if I die intestate and I leave it all to my spouse, what happens when she dies? How do I get stuff back to my kids? How do I get stuff back to my nieces and nephews or my favorite charity? I don't, unless we've set that up, okay? So there are a number of things that we can cover when we do that stuff, and also who's going to administer your estate and all that, all right? So that's just a rough overview of why those things are still needed for folks who are married, because I think there is a massive misperception that marriage, because we could not get married, that was why we had to do all those things. And I hear it on a weekly basis. So those are my reasons why I would disagree with that. Now, let's say you have an estate plan. And when I say estate plan, I mean you have a will or a trust, and you have all those powers of attorney and things that I just rambled through, okay? It is not legally necessary to update your will or your trust or your power of attorney. And when I say to note that your agent is now your spouse, what I mean is, in the document, if, let's see, a lot of wills I wrote said, my partner is John, and any reference here into my partner is to John. Now that you're married to John, do you need to amend that will to say John's my spouse? Legally, no. You were not married at the time you signed it. You can update it, but it's not legally necessary. So often, if I'm updating things for folks for other reasons, we'll then change that. Or if people just don't find it palatable that it says partner in there and they want to update it to say spouse, we can do that, okay? But you don't have to on a legal basis. Some estate planning options, however, were not available to non-spouses, especially if you have, oops, that should say estate tax issues. I apologize. If you have estate tax issues, then there were options that were not available that are now to spouses. And let me say, and I'm not going to get into a detail of the estate tax, but the estate tax kicks in, federal estate tax, if you die with more than $5.43 million. If your estate individually is worth more than $5.43 million, you will owe estate taxes at your death, which is 40% on every dollar over that limit. And if you have a spouse, you can leave it to them without having to pay that 40% tax. So there are planning tools that we can use that can take care of that. So that's, if you have that kind of issue, I'm glad to talk to you. Again, for my clients who are my clients already, I do 3-year reviews. If it's time, or even if it's not time and you want to sit down and review your stuff, we can sit down and do that for an hour. Or if you're not a client, I do free initial estate planning consultations where we sit down for an hour and have that conversation and look at all these issues. So that's just something I wanted to throw out there. So back to what happens if you're married, or what happens if you're in a civil union and you die. So these are some of the rights now that people say, well, what does it mean if I'm married? What does that get me? Okay, or what does it mean if I'm in a civil union? This one, it pertains to marriage and civil union because it's a Colorado thing. So if you die and you are married or in a civil union, your spouse or partner has a right to what's called a family allowance and an exempt property allowance. And basically what that means in Colorado is that upon the death of your partner or spouse, you have a right to ask for the first $64,000 of their estate before any creditor, Visa, whatever, okay? You have a right to the first $64,000. And that is something that does not exist if you are not married or in a civil union. Now, and what that's about is that we're trying to not leave the spouse or partner impoverished, okay? If the guy had $64,000 but he had $100,000 in credit card debt, well, the spouse gets the 64 grand and the credit card companies are out of luck. That's how it works. The second thing you should know is you cannot disinherit your partner in a civil union or your spouse, and let me say, it doesn't say it on this screen, but unless they've waived that right. But here's how it works. Absent a prenup, or what we call a marital agreement now, okay? Absent a marital agreement, when you die, your spouse or partner has a right to what's called an elective share of your estate. And roughly, what that means is they can come in and say, I get 5% of his estate for every year we were married or in a civil union. And if we've been married or in a civil union 10 years or more, I get half. So that's the max, is half. So if I die and I've been married for 12 years, my spouse can come in and say, well, I don't care that Erica left everything to her kids from a previous relationship, or I don't care that Erica left everything to her nieces and nephews, or wherever Erica left it. I get half, and my spouse would get half. They don't have to argue. It is just a given fact, okay? So if you have an estate plan and you want to leave your assets to someone other than your spouse or your partner in a civil union, you can do that, but know that they have a right to come back and ask for their share, okay? Now, one way around that would be to have them and you sign what we call now a marital agreement, a prenup or a postnup, or it's basically a contract that you sign that says, we're getting married, or we are married, we're married, and we're in a civil union, or we're going to get in a civil union, and we're going to waive our right to each other's property at death. That's one of the things that a marital agreement will sometimes cover, okay? So if you want that, you need it in writing. I've had people say, oh, they'll never come and ask for that when I die. Okay, but I'm not so sure that's usually the case, okay? So that's something you'd want to get a marital agreement. I don't draft marital agreements, but I have attorneys that I know that do, so you can always ask me for a referral if you want something there, okay? All right, the other thing is when you get married, you get obligations with that marriage. Now, I'm not sure this is that much of I don't really think it's an obligation per se, but it is a fact that when you get married or in a civil union and you dissolve that, you have to get a divorce, what's called a dissolution. Okay, or there are legal separations. I'm not going to get into the details of the difference. But basically, you have to dissolve legally the relationship. And upon doing so, if you split up your marriage or your civil union, one of you could easily be forced by a court to pay maintenance or alimony. What we used to call alimony, we call it maintenance now. Okay? And in 2014, Colorado has a fairly new law that has a formula that the judges can use to determine this maintenance. The higher wage earner ends up paying the lower wage earner generally maintenance, or can. So again, when people say, well, should we get married or not, they're not usually thinking about splitting up, but it is a consideration. Should we get married or in a civil union? Well, you just need to know if you do, and you later dissolve it, one of you could be forced to pay maintenance, okay? And also the property division will be equitable by the judge. If you two can't decide how to split everything, a judge is going to decide for you what they think is equitable in a sense. And I can tell you that the end of most divorces, nobody finds any of it very equitable. But those are the rules that you're stuck with, okay? The other things about dissolution, maintenance paid by a spouse is tax deductible. If you have to be spouses. So if you're not spouses and you split up, first of all, no judge is going to order one or the other to pay maintenance or alimony to the other because you were just partners. You weren't married or in a civil union. So you need a legal marriage to have maintenance be deductible. And the other issue is when you split up, if you start transferring assets between each other to split them up, the law says that for spouses, those are not gifts, okay? And as long as it's pursuant to a divorce. All right, oops, sorry. Federal rights you get from marriage. I'm just going to kind of talk through some of these, and some I'll be longer on and some shorter. First, immigration recognizes same-sex marriages, just like they recognize opposite-sex marriages, okay? So immigration issues, that has been helpful to a lot of clients who had immigration issues. They can now, this person is their spouse, and they're treated like that. Right, FMLA, Family Medical Leave Act. I'm sorry, I should have had that in there. Family Medical Leave Act, the right to take time off to care. It's unpaid time, generally the time off to care for a very sick family member. That applies now for same-sex spouses, okay? Colorado does have a state FMLA. I think it offers 13 weeks of unpaid time for partners in a civil union and applies to partners in a civil union, not just married people. But the federal FMLA is something you get from being legally married. The military. If you are legally married, you can get military benefits for your spouse, spousal ID card, TRICARE, dependent rate housing. You can get family separation allowances. Again, I'm not an expert in the military, but these are some of the things that same-sex couples who are married and in the military now get, okay? The Justice Department, the Federal Justice Department, will now honor all same-sex marriages. So if you are married, again, not in a civil union, you're married, you, for instance, in federal, hope you don't need these things, you can't be forced to testify against your spouse in federal court. You can visit your spouse in federal prison as a spouse. Again, I'm hoping none of you on the phone need these. The other one is spousal compensation, like when 9/11 happened. The government compensated some of the victims' spouses, and again, had to be married. So if that happens, something like that in the future, same-sex spouses will be on the same playing field there as opposite-sex spouses. So those are some federal rights you get from marriage. Social Security, okay, will also actually honor civil unions. So it's a funky thing because I've said civil unions are not recognized by the federal government. This is the one exception. Civil unions are recognized by Social Security, okay? So upon death, a surviving spouse or partner in a civil union can claim their spouse's benefits in place of his or her own if that amount is larger. So if I'm getting $2,000 a month in Social Security and my spouse is getting $1,000, okay, and I die, my spouse gives up her $1,000 and now gets my $2,000. We have to have been married 9 months before I died for that to happen, okay? So marriage gives that benefit. Unmarried, or I guess civil union also gives that benefit, okay? There's also a one-time death benefit. If you die, your spouse gets $255. Don't spend it all in one place, but that's literally the Social Security benefit. And then there's issues around the lower earning spouse can also have his or her lifetime benefit increased to 50% of the higher earning spouse. I am not an expert in all this, okay? There are people who will spend an hour on Social Security, how to claim it, or more than an hour, how to claim it, how it works if you're married, how it works if you're not married. They have software programs, all of that. If you want access to that kind of information, I can get you referred to somebody who can walk you through that, okay? But just know that I think probably the biggest one that people are aware of is the married for 9 months thing and being able to get the higher dollar figure, okay, for that spouse that's surviving. All right, If you're legally married, you must file Colorado and federal returns as married. You don't get a choice. Now, like any married couple, you can file married joint or married separate. But that's not the same as filing as two single people. So in some cases, what's commonly termed the marriage penalty means some married couples will pay more in taxes. Some will pay more. I believe it's mostly when you have a high wage earner and a low wage earner. And what it does is it drags the low one up into a higher bracket. Okay? What I would tell you is that there are CPAs who will run the numbers for you. And they can put it in the computer and do like a mock thing. File it this way married, file it this way not married, and they can tell you, are you going to pay more taxes? And I have some clients who will pay more taxes and some clients who will not pay more taxes. It just is all over the board, so you'd need to just have a CPA run the numbers, okay? And I wish I could tell you more specifically, but it really is case-by-case basis. All right, other tax issues. Unlimited lifetime gifting between spouses. So if you gift $14,000 or more per year to someone who is not your spouse, you're supposed to report that gift to the IRS. Okay? So if you take an individual bank account with $50,000 on it, and you put your partner, non-married partner, onto the account, you have just given them $25,000. Technically, that's a gift, and you're supposed to report it to the IRS. Okay? Again, I'm not a tax attorney. I'm not your CPA. I'm just going to give you the facts, and then you can talk to your CPA about whether you need to deal with those issues. Okay? So you have to be, if you are spouses, you can do unlimited gifting. So Bill Gates, as I always say, Bill Gates can give it all to Melinda tomorrow, and Melinda can give it all back the next day, and there's no gift tax implications. Okay? But non-spouses, so same-sex spouses, that same rule applies now. They can give unlimited amounts to each other without having to report it to the IRS. Next, there's no federal estate tax upon the first spouse's death. And I mentioned this. The federal estate tax limit per person this year is $5.43 million. If you die with more than that, every dollar over that, taxed at 40%. However, a spouse can leave an unlimited amount to his or her spouse with no 40% tax, okay? It's called the unlimited marital deduction, and if that's an issue for you and your spouse, then we can certainly sit down and chat about it, because I'm not going to get into great detail here, but that's just kind of the broad strokes of it, okay? Employee benefits. This is kind of a biggie. If you're not married and if the employee partner gets benefits for their partner and the employer pays it, then income taxes are going to be owed on the employer's contribution. So if my employer, I'm not married, let's say, and my employer puts my partner on our health insurance and pays $400 a month for her to be on there, I'm going to pay income taxes on that $400 every month because we are not spouses. That's just the way that works, and it's not your employer's fault. It is the way the law is written, okay? If you're married and your employer pays for your spouse's benefits, it's not taxable income to you, okay? So marriage can be helpful in that regard to some people. There has been a lot of discussion about, will companies continue to offer domestic partner benefits? Well, now that we have marriage, are they going to keep offering domestic partner benefits, or are they going to say, well, go get married, okay? I don't think any of us have any idea. We've never been in this position before. Time will tell. I would argue that they're still going to want to attract the best employees. Not everyone's going to get married. Some employers may get rid of domestic partner benefits. We'll just have to kind of see. There's probably no better answer. I think as the unemployment level stays as low as it is, they may just keep them so they can just attract the best employees and not sit around worrying whether those employees are married or not. But that will obviously depend on each employer. The other one is, do private employers have to honor same-sex marriages? I've tried to do quite a bit of reading on this. It's, it's all guessing games out there. Many experts say they don't. I would argue that probably if they don't, people are going to start to file lawsuits, discrimination lawsuits, as you've probably seen when you get on Facebook or the news or whatever, this is far from a settled answer on any of these questions. There are states, counties, governors trying to say, we're not honoring these same-sex marriages. The battle has really just begun, and so that'll be interesting. But in Colorado, it's not legal to discriminate based on sexual orientation, which includes gender identity. I think that's going to be helpful in a state like ours, but there are most states that don't have such laws. Okay, so we'll see what happens with the employee benefits. I wish I could offer you more insight specifically. I can probably get you to somebody who does employment law who may be able to shed some more light on that. But the other one is that people are saying, well, employers who don't like same-sex marriage will just get rid of all employee benefits. Okay, they might. Again, we've never been here before. But getting the best people and hiring the best employees with no benefits for them might become a little problematic if they do that. So we'll see. Many true pensions. So if you pension plans, which are fairly rare, but they're still out there, can only be left to a spouse. So if you have a pension, you need to check with if you're considering, well, should we get married or not, that might be one thing that you'd put on your list of things that might affect your decision. And that is, well, I can't leave you my pension if we're not married, and I can if we are. I would tell you, you just have to check with your pension plan. The other thing, do you have insurance coverage on your house and your car? Is there some discount if you are married? A lot of those companies already were offering discounts to even partners, not non-married partners or non-civil union partners, but that's something you might want to just check, things that can affect your decisions. Adding a spouse to ownership of real estate. If you're not married and you added your partner to ownership of real estate, it triggers what's called the due-on transfer clause of your mortgage. Not if you're refinancing them. You're not if you go get a new mortgage and you're, in essence, kind of rebuying the house with them. Refinancing with them, totally fine. But just going to the deed store and getting a deed and then deeding them on the property with you violates your mortgage. And they can call the note due. They can say, oh, we see you put your partner Bob on here, and we are now asking you to pay the entire mortgage immediately. Okay? That is called an acceleration clause, and they have a right to do that. Now, there's a federal law called Garn-St. Germain that says if you're married and you transfer the property to your spouse, or part of the property to your spouse, it is not a violation of the due on transfer clause, and the mortgage company can do nothing about it. They can't call the note due. Okay? So unmarried, be cautious of doing that. The other one is transfer of real estate upon death. If you transfer a house you own individually at your death to a non-spouse, they are likely going to have to go get their own mortgage. The mortgage company does not have to continue to let them pay your mortgage. Okay? They can force them to go get their own. Now, under Garn-St. Germain, again, a transfer to a relative resulting from the death of the borrower, the person with the mortgage, it does not trigger the due on transfer clause. Your spouse would not have to get their own mortgage. They would continue to just pay on yours. Now, again, if it's a joint mortgage, joint house, it's going to be their debt anyway. So that's one of the things that can catch people off guard. When they're not married and their partner dies, I have to say to them, well, you're going to have to go get your own mortgage, and hopefully they will be able to do that. And I've had clients who unfortunately couldn't. All right, Medicaid. Do you love how at the top of this one I put see a professional? I am not a Medicaid attorney, okay? I have two things to say, and then I have an option for you because we have an upcoming seminar in September on this issue. And so I urge you to grab a pen while I'm chatting here if you are interested in hearing about Medicaid. What happens is if I need to go to a nursing home and I don't have long-term care insurance to pay for it, Medicaid, the government, will pay for it. But I can only have $2,000, my stuff, and a residence. If I spend all my money down to there, I qualify for Medicaid. If I have a spouse, what we call the community spouse, that's the spouse out in the community. This has nothing to do with community property, or it's the spouse, the healthy spouse. They can only have $119,000-ish, okay? So I have to spend down to $2,000. They have to spend down to $119,000, and then Medicaid will pay for my nursing home. That's it. No way around it. Get long-term care insurance to pay for it, or this is what could happen. So this is one reason that some people will say, I'm not going to get married because I have a spouse who's been diagnosed with X, Y, or Z, and if I get married, I'm going to have to spend down to this level. Okay? If you're not married, your partner's assets are not taken into consideration. But there are pros and cons to both. So here's the date of the Medicaid seminar. Beth Mitchell at our office, Elizabeth Mitchell, is an attorney who deals in Medicaid. And she is teaching a class on September 12th at 10 a.m. at University Hills Library. So September 12th, 10 a.m., it's a Saturday, at University Hills. We would ask that you please RSVP if you're interested in coming to this. It'll be listed on our website within a couple days probably, if not by tomorrow, and you'll be able to RSVP. But we have space limitations, and if people show up without RSVPing, it's not very fun. So September 12th, University Hills, 10 a.m. It'll be a Medicaid seminar. Again, the issues for married couples are going to be the same now for same-sex married couples as they are for opposite-sex married couples. So it's going to cover just Medicaid and how does it work for everybody now. All right? All right. IRAs and 401ks. Talk to a qualified financial advisor because I am not one, but there are a few tools that you can use that you might not have known about. So you'll want to talk to a financial advisor. First, people with, let's say one spouse has no earned income, they don't earn income, then they can't contribute to an IRA, but their spouse can for them. And there are certain rules around all this, and again, I'm not the expert. So a worker spouse could fund a spousal IRA for the non-working spouse. That's something you could be aware of if one of you is a non-income earner. Second, at the death of the spouse, a surviving spouse can roll the deceased spouse's IRA to his or her own IRA and not have to start to take money out until they're 70 and a half. That's a good deal, because if I die at age 50 and I leave my IRA to my non-spouse, she's going to have to start to take money out the year I die. And when it comes out, it's subject to income taxes. If she doesn't need it, it would be nice if she could let it sit in there, but she can't. The government forces her to start to take it out. And as she takes it, it's taxed. All right? If she's my spouse and I leave it to her, she can put it into her own IRA or open one up for herself and let it sit and grow, if she can, if she doesn't need it, till she's 70 and a half, and then she has to start taking it. Okay? So that's something that some people will consider. The same is true with a 401k or a 403b, those kind of retirement plans. If you die, you can leave it to your, you can move it into, sorry, if you die, your spouse can move it into their own IRA and wait and delay distributions. And then the final thing about pensions and 401ks, they must be left, in many cases, to a surviving spouse, absent a waiver from the spouse. So your employer will come to you and say, you either leave this to your spouse now that you're married, or they have to sign this waiver that they don't want it. Okay? You can't sign the waiver for your spouse either. So you have to have them sign it themselves. So that's another thing to know, that if you get married, they're gonna have a right to your pension or 401k whether you want them to or not. Okay, the last thing is, if you have other questions about federal rights after the Windsor ruling, which is the ruling before this one, there's an interesting, I'm kind of a nerd that way, but there's a memorandum on the internet that you can find. It's from to the President of the United States from the Attorney General, and it has this big old huge explanation of all the federal things that were changed after Windsor to honor same-sex marriages. Okay, and it talks about farmland subsidies and all sorts of things that are affected by being a spouse, things that I never would have imagined. So I'm not going to obviously go through it, but you can Google that, and you will find that memorandum. At the time, it was before same-sex marriages were legal in every state. So it said there were exceptions like Social Security and FMLA and blah. Those exceptions no longer apply. At this point, every same-sex marriage in the country is to be treated the same as an opposite-sex marriage for federal and state purposes. Again, we have our naysayers who are trying to cause a little trouble here, but hopefully all that gets sorted out shortly, and they will find something else to complain about. Otherwise, I may not be on Facebook again for a while. So I appreciate you all attending. I have a couple of questions that were emailed in, and I'll try to touch on them here. In the meantime, you can type questions in. I'm going to try to hit them best I can. And if you have questions that you don't want to post, you can always email me or call me. I think my email was on the very first slide, but it's you can also find it on our website. Again, the firm is Ambler and Keenan, so it's ambler-keenan.com. And again, I appreciate your time. I finished up, hey, I guess right at 7 as promised. I'll hit questions now, and we'll go from there. But thank you all for coming. I hope you enjoyed it. My first question here is about a couple who was married and are in the process of finalizing an adoption of a child. If both of you have adopted the child, your rights as parents are going to be the same rights and obligations as any legal parent. Now, this doesn't indicate that you're both adopting the child. I'm going to assume that you are, which means the result will be a birth certificate that lists the two of you, mother and mother, on the birth certificate. And everything from that point, you will be on equal footing with regard to the child. You will have full legal parenting rights just as if you had given birth to that child. Okay? The other question on that was, if one of us dies, what rights does the surviving spouse or child have to the assets? Again, Social Security. If you are a legal parent of a child and you die while they are under a certain age, they get survivor benefits. And they would get those vis-a-vis both of you if you were both on the birth certificate, both legal parents. Okay, so any children where you're both on the birth certificate, the kid will get survivor benefits if one of you died. But again, and I mentioned the surviving spouse's rights, they can get the higher amount. Again, I kind of covered that, so I'm not going to reiterate that. Next question was, with a good estate plan, are there actual tax advantages to not being married? Let's see. As if one partner is retired and the other is working. Well, that's where, again, you'd need to talk to a CPA because they'd need to run the numbers. You might get into the marriage penalty situation where you're going to pay more income taxes by being married. But you'd have to have a CPA run through that, okay? Or if one partner has very high medical bills and the other doesn't. That is a question that is a little bit hard to say. Technically, medical debt or debt, I'm sorry, I'm seeing that some people were having problems with the audio, but okay. So high medical bills and the other doesn't. Medical bills belong to the person to whom incurred them. There is a doctrine in Colorado called the family use doctrine, where a medical creditor could argue that the other spouse owes that debt. It is possible. I have kind of tried to feel this issue out with bankruptcy attorneys. I am not a bankruptcy attorney. I do not know all the rules or ins and outs of that by any means. If you have real concerns about debt of your spouse before you marry them, I can put you in touch with a bankruptcy attorney who can probably shed some more light on what your liability might be vis-a-vis getting married and your spouse's debt. So while I'm not trying to punt on the question, I don't want to delve into areas of the law that I'm just not familiar with, because that's not a good idea, okay? Let's see, a question. Little Social Security data point I learned last month. Single people have basically 3 options for drawing their Social Security. Married couples have 567, literally. Talk to a professional before filing. I would absolutely agree to that. They can run numbers. It gives you way more options if you're married before you file for or start to collect on Social Security. This question says, Erica helped us plan an estate plan a couple of years ago. We now live in New York. Do we need to update our estate plan? The answer is you should have it reviewed by a New York attorney. A lot of everything I did for you was governed by Colorado law. It doesn't make it invalid in New York, but it it's governed by laws of a state that is different. So I would say have it reviewed by a New York attorney and see if they have concerns about some or all of the documents. Probably some of it needs to be updated so it complies with New York law, but that's your best bet, is to have it reviewed. And again, I urge my clients, whether they live in-state or have moved out, to get a 3-year review anyway. So my spouse and I were legally married in California last year. Phil's estate plan covers disposition of property and includes a health care power of attorney. Does Colorado law create a right for one spouse to visit another in a hospital? Yes. Colorado law does create a right for one spouse to visit another in a hospital. But in other states, I don't know. So that's why in all of our medical powers of attorney, it says, whoever I've appointed can visit me in a hospital or healthcare facility. So we don't even change it for married couples or unmarried couples. It's just in there, okay? In case of hospitalization, should we present a copy of our marriage license or a power of attorney? You would need to probably present the power of attorney. I don't think you should have to present your marriage license. Certainly they're not asking heterosexual couples for such a thing, but that's me saying that. If you have a nurse or a doctor who is opposed to same-sex marriage, I guess they could try to make you jump through some hoops. Again, being married doesn't give you the right to make that person's medical decisions. A power of attorney does. And if you are worried about not being allowed in somewhere, and again, legally they have to let the spouse in, but if you're worried about somebody trying to buck that system, you may want to have your marriage license somehow accessible, okay? How does the IRA work for a trust? Does that require immediate distribution? If you're leaving an IRA to a trust, this is a very complex issue. I could spend about 15 minutes rambling on it. I'm not going to. If the trust is not written the right way, it does require immediate distribution, or what's sometimes called a 5-year payout, okay? If the trust is written correctly, as what we call a conduit trust, it does not require an immediate or 5-year payout. If you have further questions on that, I'd urge you to kind of contact me offline, off the webinar, and I'm glad to go through it, but it's a fairly complex conversation, so I just don't want to get into too many details there. Hope you learned a lot. Enjoy the rest of your evening, and contact me. If you're a client, we'll do 3-year review. Don't forget that. If you're not, free estate planning consultation if you need me. So thank you very much, folks.